Alright, are you Justin Conley? Alright, this is case number 22-0116, J.Y. with Justin Conley. Mr. Conley, you were indicted by the grand jury back on May 3rd. On Aaron Neal. You were indicted in counts 1 through 8, which consists of aggravated trafficking and aggravated possession of drugs. Count 1 alleges on or about July 14, 2021, Aaron Neal and you only sold off himself methamphetamine and was sent to school. Count 2 alleges on or about that same day she possessed it. Count 3 alleges on or about the same day, place that Mr. Neal and you only sold off himself fentanyl-related compound. Count 4 alleges the same thing. And it was in the city school on count 3. Count 5 alleges on or about July 14th. Mr. Neal and you did only offer to sell LSD, amount over 10, less than 50 unit doses in the city school. Count 6 alleges on the same day to possess it. Count 17 alleges on about July 17 in this county. Mr. Neal and you only sold off himself methamphetamine amount equal to or greater than bulk, less than 5 times bulk, 6 people, and in count 8 alleges to possess it that day. Now, count 1, 3, 5 are all first-degree felonies. Carry a possible prison term conviction between 9 and 36 months and a fine of $10,000. Count 8 is also the same. Count 2 and 4 are aggravated possession, 5th-degree felonies. That's prison term 26 to 12 months and fine of $25,000. Count 6 is 4th-degree felony. That's there's a possible prison term of 6 to 18 months and fine of $5,000. And count 7 is a 2nd-degree felony. Carries a possible minimum term between 2 and 8 years, a maximum of 50% of whatever sentence is proposed as the maximum. And a fine of $15,000, and that's a mandatory fine of $75,000. Then all of those carry a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you, Mr. Conley, and can afford to hire one for you, and see you fill out financial disclosure forms and everything on this, correct?
Yes, sir. I had to get my other checks.
All right, the court then will find that you are entitled to appoint counsel. Court will appoint Attorney Jacob Wagner to represent you. Then who's that appointed to you?
Yes.
Right. Jacob Wagner. They're not guilty plea if they recant. Set a bail review hearing for Tuesday, the 17th at 11 a.m. First pre-trial, let's see. First pre-trial will be June 1st at 1 o'clock p.m. Both of those will be by Zoom. The final pre-trial will be June the 22nd at 1 o'clock by Zoom. Trial date will be July 14 at 8 a.m. All right, the bond will be set in the amount of $25,000, unless your own cognizance of the sure promise will appear. If you fail to appear, then you could be prosecuted for additional felony and convicted. Next on advertising after the case, we required to pay a service fee, deposit of $171 prior to release. You also, as a condition, bail, get a pre-trial supervision probation department on 117 East Main Street. Your report then immediately after court, and then 1 week to 4 weeks, after release, you should say. And then after that, 1 week to 4 weeks, and after that, as they determine the random drug testing in order by phone with your home employer, no contact with co-defendant Aaron Neal. If recommended by probation, you can be evaluated for substitution, mental health issues, and treatment indicated to enroll in all that or attached to this action. You also be under house arrest at your residence at 154 Willow Street. In Hillsborough, you have to get it all the time, unless you're working, going to and from work, medical appointments, court proceedings, this or any other case. You may attend appointments with an attorney or probation officer, in this or any other case. You also attend any kind of educational programming, job training, and that type of thing, as well as church services. So then you have to be there all the time. And if you fail to comply with any of your conditions, that the court could revoke that bond and we have to further forward. All right, we will notify your attorney of his appointment and the hearing on Tuesday morning to review the bail order. You have any questions? All right, thank you. Is this that one?
Yes, sir.
All right, who we got?
Mr. Smallwood.
All right, Kyle Smallwood,
Yep.
Very good. Anything else after that?
Sarah Wood.
Oh, yeah, okay.
Was I supposed to appear in person today?
What's your name?
Sarah Workman?
Yeah.
Okay.
Who's your attorney?
I'm trying to retain Aaron Ross.
Oh, okay, gotcha. All right, we'll talk about that. All right, are you Kyle J. Smallwood, attorney there for the jail? All right, this case number 22 CR 78, State of Ohio versus Kyle Joshua Smallwood, attorney being conducted by Zoom. The defendant's attorney is Dennis Kirk. Attorney from his office and attorney from the prosecutor's office is the prosecutor King. In 22 CR 78, the defendant was indicted for trespassing and habitation for first time to be present. There was a request for a examination of the mental status of the defendant. The court ordered that, and I received that report, and each of the attorneys received a summary. Or actually, a copy. All right. Does either party wish to offer any additional evidence beyond the beyond the report?
Nothing else to say, Your Honor.
All right. Well, the court will also note that the defendant was indicted in case number 22 CR 110, and he was arraigned last week on the same charge for trespass and habitation, and also menacing by stalking, 43 felonies. I think I was indicated that the arraignment was on entry, and then I got notice that this report was in, it wasn't necessary to do. I'm just going to add that to this particular issue, but in court's view, the report addresses is fine that he's not currently compromised required by law, and therefore there's going to be order of second evaluation court by the findings that the court ordered both cases of grand objection at Mr. Burke and Mr. King.
Your Honor.
All right. All right, well, the report from Dr. Greer, D-R-A-Y-E-R, Carla, C-A-R-L-A, psychologist, indicates that defendant is not currently capable of understanding the proceedings persisting as to the active symptoms of mental illness, and is therefore, in her opinion, a competent stand trial to her opinion that he can be restored to competency in the time allowed by law, given proper course of treatment. And given the nature of this charge, as well as the charge of the new case, both of which are violence, or at least involved with threat violence, the recommendation is he be least restrictive setting of restoration consistent with his needs and public safety, his Twin Valley behavioral health care, and therefore the court will order that the defendant be found not competent this time, stand trial, but the likelihood that he will be restorable given treatment, and therefore it's ordered that he be admitted to the Twin Valley Behavioral Health Center for treatment to restore his competency, and until then, he'll be remaining in jail until he is paid there for treatment. Now, I know we've been running into delays there because of COVID and short staffing, and don't know that they're operating at full capacity. And so it may be a couple, 3 weeks, perhaps even more, before he'll be paid there for treatment. So until then, he'll remain in jail. The court will order that both cases be put on the inactive docket, pending the report from the Valley once they are able to start this course of treatment. All right. Is there anything further in council? All right, Mr. Smallwood, I can't tell you when they're going to come get you, but they will. But it could be like I said, it could be 2 to 3 weeks. Just depends on their openings that are running at full capacity right now, at least their capabilities of capacity. So that'll make a decision. So whenever they come get you, they will. All right. Thank you.
Your Honor?
Yeah.
Do I need to come over to the courtroom for the status on?
No.
Okay, thank you.
So this is done soon? Done soon?
Yes. You want to come here and have a seat?
Where?
All right, this case number 22-0121, State of Ohio versus Sarah Workman. You're Sarah Workman?
Yes.
All right, so, hearing out counsel, I bring her into the, and she did lay on. So we have a pre-trial set June 1st. Questions for the court was about counsel. What's the situation with counsel?
We're just working on getting the retainer for Aaron Moss for an attorney.
Okay, and when do we expect to be able to do that?
Clear within the next week.
Okay. What's the name again?
Aaron Moss.
Aaron Moss.
Yeah.
Where is he from?
I know he takes care of like the Brown County, Claremont County area.
Okay. All right, well, make sure there's appearance of the right way. Do that pre-trial will not be first, so that will be listed. So, if there's appearance, okay, that's of course the same.
Okay.
All right, thank you.
Is that all?
Yes. Please rise.